I said put your hands on the car.
You're arresting me for
Put
what?
your hand back up.
Hey, don't you put your Hey, God, I'm so dizzy right now. He just banged my. Oh my God! Oh my God!
Shut up. Stop moving.
He's pulling my hair.
Sit down.
Get in the car! Get in the car!
Oh my God! I can't. I'm too big.
Sucks to be you. Get in the car!
I didn't do anything. You're a woman. You're gonna treat me like this?
You're going to get tased. Get in the car.
Listen.
Get in the car.
Get in the car!
I'm getting in the car. Okay, I'm in.
Gerard was escorted to the police unit. She continued her refusal of compliance. That is one line from a police report filed in East Ridge, Tennessee. Now, watch the body camera. A mother stands beside her own car, hands empty, calm, and an officer grabs her, slams her against her own window, and pulls her hair while she is already in handcuffs.
Because I smell marijuana.
2 accounts.
Smell
One
marijuana.
video.
Yes.
Because you
Only
smell
one of them is
marijuana
true.
that gives you the right to run my.
Picture a small square of glass on a car door. That window is where a mother's face is about to be pushed. And for the next few minutes, that little rectangle of glass becomes the only witness the government cannot silence. Before we go further, make sure you're subscribed to Police Misconduct Case, because we don't just cover the story, we follow the evidence. It starts as the most routine call an officer can get, a welfare check. No name, no details, just a request to knock on a door. Officer Teddy Dyer of the East Ridge Police Department pulls up at night. Parked outside is a car. Inside sits Angel Sherrard, a mother, waiting for her daughter. Not a suspect.
In the late evening of December 3rd, 2021, Officer Teddy Dyer, Officer Candace Miller, and Sergeant David Myrick of the East Ridge Police Department in Tennessee responded to a call for a well child check at the residence of Haley Sherrard. When they arrived at the home, they found Haley's mother, Angel Sherrard, along with her son, Devin, in a vehicle in front of the house. Officer Dyer approached the vehicle from the right passenger side, and the encounter that followed was captured on his body camera.
Hello.
Hey, what's up?
Hey, do you live here?
My daughter's living here.
Is she? In this, is that 893?
Yeah, it is.
All right, hang on one second for me, okay?
Something wrong?
Well, we got called to check on a child.
What
Well,
child?
I don't know. They didn't tell us. They just said do a welfare check.
From when? Like, what did they say?
I don't know. We'll go up and knock. Is that your daughter coming now?
Yeah.
What's her name? Hey, going up to the door.
Well, how old's the child?
2 years old? Is there a 2-year-old that lives here? Okay.
I bet it was,
Not a crime scene. A woman sitting in her own vehicle, doing nothing. Dyer walks up, polite at first. Then one sentence changes everything. You running my tag? 'Cause I smell marijuana.
4 Mike 3, 7 Golf 4.
Why are you running my tag?
Because I smell marijuana.
You smell marijuana.
Yes.
Because you smell marijuana that gives you the right to run my tag?
Not only that, I'm going to search your car.
You're not going to search anything.
Yes, ma'am.
No, you're not.
I promise you.
You are
and
not going to break
not
my
only-
rights right now.
You're about to get your rights up in the back of my car.
Well, that's what you want to do because
51
you're
to
going to get in real
67
big when you do. Because I haven't done anything. I haven't
51 to
violated any rule
479.
or anything. You just sit there and talk to me and to
Now
tell
that-
me you're going to
that-
search my car.
I am going to search your car.
And you're running my tag.
I am going to
I'm not
search your
doing
car.
anything but sitting out here waiting for
I
my
don't
daughter
care.
to come back
I
out.
don't care. Your car's going to be searched. And if you interfere with my search, I will put you in the car and I
Okay,
will take you to
if you
jail.
go ahead and you violate my right, you're going to put. You're
I said
arresting
put
me?
your hands on the car.
You're arresting me for
Put
what?
your hand back up.
Hey, don't you put your. Hey, God, I'm so dizzy right now. He just banged my. Oh my God! Oh my God!
Shut up. Stop moving.
He's pulling my hair.
Sit down.
Get in the car! Get in the car!
Oh my God! I can't. I'm too big.
Sucks to be you. Get in the car!
I didn't
Get in.
do anything. You're a woman. You're gonna treat me like this?
You're going to get tased. Get in the
Listen,
car.
listen.
Get in the car.
Get in the car!
I'm getting in the car. Okay, I'm in.
6 words, that turn a welfare check into a criminal investigation. No warrant, no visible contraband, just a claim that can't be tested or disproven on the spot. And under Tennessee law, that claim alone is enough. In 1976's State v. Hughes, Tennessee's Supreme Court ruled that the smell of marijuana gives police probable cause to search a car, a rule courts reaffirmed even after hemp, which smells identical, became legal. So legally, if Dyer actually smelled marijuana, he had the right to search. The whole case balances on one invisible, unprovable claim. That isn't law enforcement. That's a permission slip an officer writes for
Sitting out here
himself.
waiting for
I
my
don't
daughter
care.
to come back
I
out.
don't care. Your car's going to be searched. And if you interfere with my search, I will put you in the car and I will
Okay,
take you to
you
jail.
go ahead and you violate my rights then.
Okay, put
Let's
your hands
do
on the
that.
car.
You violate my rights.
Put your hands on the car.
Officer Dyer claims he is going to run the vehicle's tags and search it because he smells marijuana. Tennessee is one of the minority of states that, as of the date of writing this episode, have not legalized or decriminalized either recreational or medical marijuana, although the state has legalized hemp and CBD oil. Accordingly, in the 1976 case of State v. Hughes, the Supreme Court of Tennessee held that the odor of marijuana coming from a vehicle constitutes probable cause to believe that the vehicle contains contraband marijuana. In the 2022 case of State v. Hampton, the Court of Criminal Appeals of Tennessee rejected an argument that with the legalization of hemp, the quote-unquote plain smell of marijuana no longer established probable cause for a warrantless vehicle search, as the smell of marijuana is indistinguishable from the smell of hemp, concluding that, now quoting, "Until our Supreme Court or our legislature determines otherwise, the smell of marijuana continues to establish probable cause for the warrantless search of an automobile." Accordingly, if a court believed Officer Dyer's assertion that he
Sherrard doesn't scream or threaten. She simply asks, "That gives you the right to run my tag?" A fair question. It becomes the reason her night ends in a hospital bed. Here is the first moral refrain. Remember
jail
it
too.
because it
Get
repeats.
back.
The badge does not make the story true. The badge does not make the story true.
Who did what?
Within seconds,
She didn't get
Dyer
tased.
pulls her from the car. The video shows her pressed into the door, face against the glass. The federal lawsuit her family later filed says Dyer slammed her face onto the window, banged her head on the vehicle, handcuffed
You
her,
want to act like
then
a big girl?
pulled her
You're
hair
going to get treated
back
like a big girl.
after
So I
the
drive
cuffs were
son
already
to mom
on.
to get her in the car.
Handcuffed, not
Other than that,
resisting,
she's perfectly fine.
hair pulled anyway.
The Supreme Court explained in the 1986 case of New York versus Class, quote, "A citizen does not surrender all the protections of the Fourth Amendment by entering an automobile. Nonetheless, the state's intrusion into a particular area, whether in an automobile or elsewhere, cannot result in a Fourth Amendment violation unless the area is one in which there is a constitutionally protected reasonable expectation of privacy." The court then held that an officer did not violate the Fourth Amendment by reaching into the passenger compartment of a vehicle stopped for a traffic violation to move papers obscuring its vehicle identification number, or VIN, or VIN, reasoning that individuals do not have reasonable expectations of privacy in their VINs, as they are required by law to be located in a place ordinarily in plain view from the exterior of the automobile. Applying this and other precedents, courts have generally concluded that there is no reasonable expectation of privacy in a license plate number, and that officers may therefore run tags of a vehicle in plain view without implicating the Fourth Amendment. For instance, in the 2006 case of U.S. versus Ellison, the Sixth Circuit Court of Appeals, which has jurisdiction over Tennessee, determined that, quote, "So long as the officer had a right to be in a position to observe the defendant's license plate, any such observation and corresponding use of the information on the plate does not violate the Fourth Amendment. As such, a court would almost certainly find that Officer Dyer was within his constitutional authority to run Ms. Sherrard's plates, regardless of whether or not he actually smelled any marijuana."
Yo, what are you? You're gonna put.
I said put your hands on the car.
You're arresting me for
Put
what?
your hand back up.
Hey, don't you put your. Hey, oh God, I'm so dizzy right now. He just banged my. Oh my God! Oh my God!
Shut up. Stop moving.
He's pulling my hair.
Get in the car. Get in the car.
Oh my God! I can't. I'm too big.
Sucks to be you. Get in the car.
I didn't
Get in.
do anything. You're a woman. You're gonna treat me like this?
You're gonna get tased. Get in the
Listen,
car.
listen.
Get in the car.
Get in the car.
Okay, I'm in.
Although it is
Ask yourself the question this case forces on every viewer. If the second officer's body camera had truly been lost that night, would anyone have ever believed her? That's the ticking clock here. Not a bomb, but a piece of footage that almost didn't exist. Then it gets bigger. Officer Anna Simmons arrives, and Sergeant Myrick drive-stuns Sherrod with a taser as she struggles to fit into the back seat, after she's told them, clearly, she physically cannot fit.
Sherrod's attorney detailed the officer's use of force against her in a federal lawsuit stemming from this encounter. According to the complaint, Officer Dyer grabbed Ms. Sherrod, slammed her face onto the partially opened window of her vehicle, banged her head onto her vehicle, and handcuffed her. The lawsuit also asserts that Officer Dyer then pushed her against the back of a police vehicle and jerked her head backward by grabbing her hair after she had been handcuffed. A few moments later, after Ms. Sherrod was escorted to the police vehicle, Officer Anna Simmons arrived on the scene, and Sergeant Myrick, quote-unquote, drive-stunned Ms. Sherrod with her taser as she struggled to get in the vehicle. The term drive-stun refers to holding a taser device against the target without firing the projectiles, which is intended to cause pain, but not incapacitation. Despite the fact that Ms. Sherrod explicitly told the officers that she did not believe she was able to get into the back of the vehicle due to her size, Officer Simmons chose to leave this fact out of her police report, which Lackluster obtained and included in his video. According to Officer Simmons' narrative, now quoting, Sherrod was escorted to the police unit, however, continued her refusal of compliance and would not get in the vehicle. Police continued to give numerous lawful orders to get into the police unit, and she did not comply. Police drive-stunned Sherrod to gain compliance, which was successful. Now, as we've discussed before here on ATA, whether or not the use of force during an arrest or investigatory stop Sherrod did struggle during her arrest, she would still have a legitimate argument that pulling her hair after she was handcuffed and banging her head against the car was excessive.
Shut the up before I take your to jail too. Get back.
She just got run having a baby. You do not
Go
need
away.
to arrest her. Girl, do not push me. What is wrong with you? Who did it? I need to know who did it.
Who did what?
Who tased my mama?
She didn't get tased.
Then why was there a taser going off over there?
Checking the fire, I guess.
So then why was there a taser?
How about you worry about you? We'll worry about your mama. I don't really give a
Y'all are violating our rights right now.
Which one?
You want to act like a big girl, you're going to get treated like a big girl. So I drive-stunned her mom to get her in the car. Other than that, she's perfectly fine.
Just drive-stunned? I'm just making sure.
Yeah, no, she just drive-stunned. But I did it twice. I'm emotionally invested. Can I take her?
Yes. Well, we were thinking.
I love it when you do this.
Going to the hospital, I'm going to come. I'm talking. I'm telling you what's going to happen, okay?
You are very rude.
Taking mom for disorderly conduct, resisting stop, halt, frisk.
Officer Dyer states that he is taking Ms. Sherrod to jail for disorderly conduct and resisting. Under Section 39-17-305 of the Tennessee Code, quote, a person commits an offense who, in a public place and with intent to cause public annoyance or alarm, engages in fighting or in violent or threatening behavior, refuses to obey an official order to disperse issued to maintain public safety in dangerous proximity to a fire, hazard, or other emergency, or creates a hazardous or physically offensive condition by any act that serves no legitimate purpose. Further, the statute states that, now quoting again, a person also violates this section who makes unreasonable noise that prevents others from carrying on lawful activities. In this instance, Ms. Sherrod's actions did not appear to rise to the level of disorderly conduct because, although she spoke assertively, she did not even raise her voice at Officer Dyer until right before he grabbed her, and certainly did not make unreasonable noise, engage in fighting, violent, or threatening behavior, or create a hazardous or physically offensive condition. In fact,
Said to a handcuffed, tased mother struggling to fold into a car door too small for her. Simmons then admits she is emotionally invested in seeing Sherrod processed. Not procedure, not necessity, emotional investment in punishing a woman who committed no crime.
argument that pulling her hair after she was handcuffed and banging her head against the car was excessive.
Shut the up before I take your to jail too. Get back.
She just got run having a baby. You do not
Go
need
away.
to arrest her. Girl, do not push me. What is wrong with you? Who did it? I need to know who did it.
Who did what?
Who tased my mama?
She didn't get tased.
Then why was there a taser going off over there?
Checking the fire, I guess.
So then why was there a taser?
How about you worry about you? We'll worry about your mama. I don't really give a
Y'all are violating our rights right now.
Which one?
You want to act like a big girl, you're going to get treated like a big girl. So I drive son to mom to get her in the car. Other than that, she's perfectly fine.
Just drive son? I'm just making sure.
Yeah, no, she just drives son. But I did it twice. I'm emotionally invested. Can I take her?
Yes. Well, we were thinking.
I love it when you do this. Going to the hospital, I'm going to come. I'm talking. I'm telling you what's going to happen, okay?
You are very rude.
Taking mom for disorderly conduct, resisting stop, halt, frisk.
They are now. So.
Officer Dyer states that he is taking Ms. Sherrard to jail for disorderly conduct and resisting. Under Section 39-17-305 of the Tennessee Code, quote, a person commits an offense who, in a public place and with intent to cause public annoyance or alarm, engages in fighting or in violent or threatening behavior, refuses to obey an official order to disperse issued to maintain public safety in dangerous proximity to a fire, hazard, or other emergency, or creates a hazardous or physically offensive condition by any act that serves no legitimate purpose. Further, the statute states that, now quoting again, a person also violates this section who makes unreasonable noise that prevents others from carrying on lawful activities.
But the car can just stay here. I mean, I'm
We'll
her
see.
daughter.
I
Please
see.
don't, it's already, please don't, because, I
Let's
want
go.
to bond her out of jail, and I just had a baby.
And I feel for you, and I'm not trying to cause you no headache. You just got to understand we have a job to do also. Step out. Let's talk. How old are you, man?
I'm 18, sir.
18.
And I'm a man. And like you, why you gotta hit my mama like that, bro?
You gonna keep the? All right. I tried. You see, I tried to talk to you like a man. I tried to talk.
Why'd you have to do her like that, bro?
Get in the car. I tried to talk to you. I tried. I'm not your bro. You see, I tried. You see, I tried to talk to you.
How old is he?
18. He's old enough to take a ride. He goes to the big boy jail. Listen, I want you to know how this would have went. Ma'am, I'm gonna have to search your car. Okay. I didn't find anything. Guess what? Have a good night.
So conducted the well child check and found the child in question healthy and happy inside the home. Ms. Sherrard was transported by EMS to a hospital where she was medically cleared and then charged with disorderly conduct and resisting arrest. The officers released Haley and Angel's 15-year-old daughter, who had been handcuffed during the encounter, but Devin was charged with disorderly conduct. On April 19, 2022, the state of Tennessee dismissed all charges against Angel and Devin. On July 12, 2022, Angel, Devin, and her minor daughter filed a lawsuit in state court, and the case was removed to federal court on August 11, 2022. The lawsuit alleged multiple constitutional violations and state law tort claims against the individual officers involved in the encounter, as well as the city of East Ridge. On September 21, 2023, the Sherrards reached a settlement agreement with East Ridge. Although the amount received by the adult Sherrards has not been disclosed, due to Tennessee laws requiring court approval of settlements and legal fees for minors, we know that Ms. Sherrard's minor daughter received a settlement of $10,000, with $4,000 of that sum being paid to her attorney. Now, although the population of East Ridge is less than 22,000, the Sherrards' lawsuit is not the only civil rights case that has recently been filed against the city alleging police misconduct, including a case where Officer Dyer is accused of using excessive force against a citizen, and Officer Miller is accused of failing to intervene, and another lawsuit alleging that Officer Simmons used excessive force in preventing a patient from leaving a hospital. On December 22, 2022, the East Ridge Police Department fired Officer Simmons for so-called use of force and so-called discourteous behavior during another encounter. On December 29, 2022, it was confirmed that Officer Simmons had been hired by the Bradley County Sheriff's Office less than a week after her termination, as she was reported as the department's first responding officer to a car accident on Christmas Day. In May of 2023, Officer Simmons resigned from the Bradley County Sheriff's Office for undisclosed reasons. No disciplinary action has been publicly reported for the other officers involved in the encounter with the Sherrards. Overall, the East Ridge officers get an F for using unnecessary force against Ms. Sherrard, blatantly misrepresenting Ms. Sherrard's conduct during the encounter in an apparent attempt to manufacture criminality and justify their actions, and seeming to take pleasure in subjecting Ms. Sherrard to both physical abuse and emotionally demeaning behavior. Officer Simmons in particular seemed to relish misusing her authority, telling Ms. Sherrard, and I quote, "sucks to be you," when she revealed that she could not fit in the backseat of the police vehicle, and openly admitting that she was quote-unquote emotionally invested in seeing Ms. Sherrard be processed, despite the fact that she had not committed any crimes. There are too many issues with the officer's behavior in this encounter for us to discuss all of them, but on the whole, they remained unprofessional, aggressive, and cruel throughout the interaction, and likely violated the constitutional rights of all of the present members of the Sherrard family. Ms. Sherrard gets an A- because while she was mistaken about the legality of Officer Dyer's decision to run her tags, she opposed a potentially illegal search of her vehicle, fought the charges against her in court, and took proper legal action against the officers after the encounter. Although the search of her vehicle may have been lawful if Officer Dyer actually smelled marijuana, given the clear lack of honesty in the way the East Ridge PD represented other aspects of the encounter and the absence of marijuana in the vehicle, it is more than plausible that Officer Dyer was simply lying about the odor, which would make the search clearly unconstitutional. Beyond that, the physical force and verbal abuse that Ms. Sherrard and her family were subjected to during this altercation was inexcusable, and I commend the Sherrards for filing a lawsuit to attempt to hold these officers accountable